Last year was an interesting year in data privacy. A lot happened, but in this video, continuing our Think Law series, we're going to focus on international data transfers. And for this, I'm joined by my colleague and head of KPMG Law's Data Protection Department, Emma Ritchie. Emma, firstly, the data privacy framework is now in place. It's been up and running for about 6 months. And with that in mind, can you give us an update on the status of EU to US data transfers?
Yeah, of course. I think the first thing that's really positive here is the certainty that we now have when it comes to transferring data from the EU to the US. And this is particularly welcome after so many years of turbulence between the invalidation of Safe Harbour and the Privacy Shield. So eligible US organisations can self-certify their participation in the framework, where they're basically committing to comply with the safeguards set out in the EU when it comes to processing personal data. And I think what's really important when it comes to international data transfers is trust. And the framework really achieves this trust because it addresses a lot of the concerns that were raised in the past when it comes to transferring data to the US. And for this reason, we really think that this transfer mechanism will be a success.
Yeah, you mentioned the key thing there being trust. It's crucial for international data transfers. And we see the data privacy framework in place to cover EU to US transfers. Can you explain to us how that trust is established when it comes to other countries and the EU?
Yeah, so the GDPR sets out different mechanisms that can be relied upon for transferring data internationally. We've obviously discussed the framework, but adequacy is another safeguard that can be relied upon. And that basically means that the European Commission has, done a quite serious investigation and review of a country and determined that their commitment to data privacy is similar to that of the EU. These decisions are reviewed every 4 years. And so far, we have 15 countries that have been granted adequacy. We've obviously discussed participation when it comes to the framework for the US, but some examples of other countries would be South Korea and Japan that have been granted adequacy. Outside of adequacy, as I mentioned, there's a lot of different safeguards that can be relied upon. But one of the appropriate mechanisms, let's say, for transferring personal data would be reliance on the standard contractual clauses.
So we see a few different ways that a data transfer outside the EU can be justified, which really highlights the importance of knowing exactly what data you have. A data mapping exercise is always useful here, and knowing exactly where that data is going to get comfortable relying on a particular transfer mechanism. Emma, to close us out, predictions for the coming 12 months. What do you see in store for international data transfers?
Yeah, so I think the first thing that we'll see in the first half of this year will be a review of the data privacy framework, just to make sure it's functioning effectively and efficiently. Secondly, on adequacy, late last year, there was reviews of the countries that have been granted adequacy. So we're eagerly awaiting to see what, if anything, comes out of that, if there's any changes and anything that our clients would need to do when they're transferring data to those countries. And we're also hoping that a decision will be reached in terms of Brazil getting granted adequacy. So really there is a lot to keep an eye out on in this space. So we encourage our clients to keep an eye on our website where we'll be updating as news rolls in.